Okay, so I'm going to make a quick introduction. So my name is Garrett Lloyd Lester. I'm the coordinator for community and coalition initiatives at the Suicide Prevention Center of New York State. And as part of ongoing support and assistance to coalitions and coalition partners across the state, we offer these occasional, what we refer to as coalition academies. They're more or less lunch and learns on topics that we hope are of interest to suicide prevention coalitions. And one of the areas that many coalitions are interested in as it relates to strategies is looking at lethal means safety, right? How do we put time in between individuals experiencing thoughts of suicide and acting on those thoughts? And there's different tools and strategies to do that. And today we're going to take a look at one of the tools that's in New York State to address that, but also not just specific to the topic of suicide, but also looking at interpersonal violence and gun violence in general. So with us this afternoon is Lisa Geller, who is the State Affairs Manager at the Educational Fund to Stop Gun Violence and the Coalition to Stop Gun Violence in Washington, D.C. Lisa began working at EFEB and CSGV in June of 15. Lisa manages advocacy and implementation of evidence-based gun violence prevention policies at the state level. Her main area of interest with gun violence prevention is in the intersection of firearms and domestic violence. She's been conducted research into the role of domestic violence in mass shootings. Additionally, Lisa manages disarmdv.org.
I can see that about him.
Folks can mute themselves, please. That would be great. A comprehensive and interactive website that compares laws between states, presents statistics about domestic violence and firearms, and provides information on the statutory process of firearm removal in cases of domestic violence protective orders. Lisa graduated Phi Beta Kappa from Wisconsin-Madison, where she earned her bachelor's degree in political science. She earned a master's of public health in policy from Johns Hopkins Bloomberg School of Public Health. Co-presenting with Lisa today is Rebecca Fischer, and as the Executive Director of New Yorkers Against Gun Violence, Rebecca leads the only statewide organization that focuses on empowering young people to use their voices to call for action to reduce gun violence, transforming New Yorkers Against Gun Violence Education Fund into a major player in both advocacy and school-based gun violence prevention education. As a policy expert and lawyer, Rebecca is a respected source in local and national media, having been quoted in the New Yorker, New York Daily News, Albany Times Union, NPR, MSNBC, New York One, and Capital Tonight, among others. Rebecca is a graduate of Tufts University with a BA and a Benjamin N. Cardozo Law School, JD, and lives with her family in Brooklyn. And with that being said, I am going to turn things over to Lisa and to Rebecca. If you have questions, certainly please feel free to put them in the chat. We'll be monitoring them throughout, and we'll either try to insert those questions during the course of content, as well as making sure there's time at the end of the workshop for questions. And with that being said, I'm going to turn things over to Lisa and Rebecca.
Great. Thank you, Gara, for having us, and glad to see there are a number of people that are tuning in this afternoon or wherever you are, morning or evening. We are really excited to talk to you about extreme risk protection orders, which are just one of the various tools that exist to prevent gun violence and specifically firearm suicides. Before we get started, we would just love, I'll try to be monitoring the chat as I share my screen, but I would love to know who you are, where you are calling in from, and kind of what group you belong to, law enforcement, advocate, lawyer, any of those things. So please feel free to put that in the chat so we get a sense of who we're talking to. Great. This is just a brief overview of what we're going to be talking about today. And as Gara mentioned, feel free to put your questions in the chat at any time. We will also leave time at the end to talk about anything that you would like to talk about. So just to get started, I want to give the overview of gun violence in the United States. Rebecca is going to talk specifically about New York. But this really is a public health crisis that kills almost 40,000 people every year. Unfortunately, 2019 is the newest, the most updated data we have on firearm mortality in the US. We should be getting 2020 in the next couple of months, but in 2019, nearly 40,000 people died from gun violence, about 108 people every single day. The majority of gun deaths in the US and in New York are firearm suicides. The rest are homicides, unintentional injuries. And I also want to mention that about twice as many people as die from gun violence are injured with a gun every year. So we're talking about 120,000 people who either die or live with firearm injuries every single year in this country. And 2019 was the third consecutive year of nearly 40,000 gun deaths in the US.
Thanks, Lisa. I just want to make sure everyone can hear me okay. Lisa, can you hear me?
Yep.
So before I talk more specifically about gun violence in New York, I just wanted to thank you all for having me here today. Specifically, thanks to Gara and to Lisa for doing so much preparation in advance of this program. And I also wanted to recognize, as the participants start to put their expertise and job titles into the chat, that we recognize we're coming to the table with one perspective, but that we're really here with experts that work in this field every single day. And, we're very interested in hearing from you as to what you're experiencing from whatever perspective you may have to offer in the area of gun violence, but more specifically in suicide or domestic violence. I see, law enforcement, I see folks who work in victim crime services. So we hope that this is just the beginning of a conversation to figure out how we can work as partners and be supportive, both from the advocacy perspective, but also from an education and implementation perspective. As many folks know or may not know, New York has one of the lowest gun deaths and injury rates in the country. And so often it's not necessarily focused on a national scale as being a crisis, but it is. This is really just comparative. And because the gun violence crisis is an epidemic across the country in the United States, it's all relative. So in fact, last session, the legislature actually declared gun violence a public health crisis in New York State. And so hopefully that will get more attention to what the problem is. As Lisa pointed out, the most recent data is from 2019, in which there were 804 firearm deaths in New York, of which over 50% were firearm suicides, which I think is a really important point, especially for this group to be made, because that's not frequently in the news. Suicide is stigmatized in such a way that it's generally kept more private. A lot of them are not reported. And so it's important to note that it's still such a large percentage of firearm deaths in New York. That being said, these numbers are from 2019. And as most of you who work in this field probably know, the rates have significantly spiked since the outbreak of COVID-19 in March 2020. In most of our cities, more than 50%. And so we're continuing to look at many different tools that we can use, and extreme risk protection orders are one of them. Hand it back to you, Lisa.
Mm-hmm. Great segue. So this is what we're here to talk about, extreme risk protection orders. For those who are not familiar with this tool, it is a civil court-issued order similar to a domestic violence protection order that temporarily prohibits individuals that are at risk of violence, either self-directed violence or interpersonal violence, from purchasing, possessing a firearm, rifle, or shotgun. And in some states like Illinois, it also prohibits purchase of ammunition. So 19 states and the District of Columbia have extreme risk laws as of October 2021, and nearly every state has introduced extreme risk law legislation. The names vary slightly by state. In New York, it's called ERPO, or Extreme Risk Protection Order. In Delaware, it's called a Lethal Violence Protection Order. In Virginia, it's called a Substantial Risk Order, and so on and so forth. But really, the laws are all the same in that they're civil protection orders that are temporary firearm removals when someone is at risk of harm, again, towards self or others. And what we know from the data of these laws from the past 6 or 7 years that we have some data, is that they're most often used for suicide prevention purposes, which is why this is a great audience to talk to today. And most respondents of these orders are older white men, which this group probably knows is the group at the highest risk of suicide in this country. So now we'll talk, Rebecca will talk a little bit about New York's law specifically.
So thanks, Lisa. Yeah, in New York, we started working on, you know, an ERPO bill, previously called a gun violence restraining order, back in 2016. And, you know, through advocacy and coalition with the Coalition to Stop Gun Violence, other gun violence prevention advocacy groups, but also law enforcement, mental health providers, national and New York community violence, you know, prevention programs as well. We were able to get this law passed in 2019, particularly after the New York State Senate flipped. We had enough political will to be able to pass a law like this. And as Lisa mentioned, New York is one of many states that have passed a law called an extreme risk protection order, I think in part because this is a tool that's really intended to be utilized to keep guns away from individuals in crisis. It specifically looks at, you know, whether or not the individual has a record of dangerousness or has been a threat to themselves through suicidal ideation. It's evidence-based, and so there's been a lot of receptivity to it. And in New York, in particular, it was important to the governor at the time and to many education institutions across the state to add school administrators as individuals who have standing to petition for an ERPO in civil court. So you can see that law enforcement, district attorneys, family, household members, and school administrators can petition for an ERPO. I just want to point out, though, and we'll get into this in more detail, that I'm sure there are a lot of folks on this program that may not fall into any of those categories. And that does not mean that you, as an individual who may be closest to the issue, doesn't have a role in being able to work with any of these different individuals in getting an ERPO petition filed.
Great. And before I advance to the next slide, which is some data from New York State, as Rebecca mentioned, these are evidence-based orders. They're not based solely on a mental health diagnosis. This was very important in crafting this policy, that we didn't unfairly stigmatize those living with mental illness, because we know that while mental illness does contribute in some cases to interpersonal violence and certainly to suicide, it's not the only criteria. And actually, people living with mental illness are much more likely to be victims of violence than perpetrators. And so every time we, at my organization, advocate for these laws nationwide, we push back hard against the narrative that this should be issued for a mental health diagnosis or for someone, exhibiting that kind of behavior. We want to look at all behaviors. We want to look at threats of violence. We want to look at domestic violence, threats with a firearm, recent acquisition of firearm for a dangerous purpose, and not just mental illness. So I want to make sure that I say that.
There was a quick question in terms of which court has jurisdiction to hear these petitions. Oh,
yes. Great question. So we'll talk a little bit about the process, but the New York Supreme Court hears the extreme risk protection order petitions, and we have a number of resources at the end. So there's temporary orders and final orders, and New York Supreme Court hears both of those. The burden of proof is slightly different for the temporary and the final, just the same for a domestic violence protection order. But we will provide tons of resources, including, in a minute, Rebecca's going to go through what the actual court form looks like to fill out an extreme risk protection order.
Yeah, I will talk through the court process in more detail so it feels as accessible as possible, because it can seem like something that's outside the purview of, individuals who don't work, in the law every day.
Yes, like me. That's why I have my lawyer, Rebecca, on. So what does this look like in New York? This is a screenshot. It might be very, very small, but again, you'll receive a copy of these slides and all of the materials that we cover today. I have a great contact at the New York court system who sends me data every time I ask for it. And so this is as of October 19th. So I asked him last week. And in the past, 2+ years that this law has been in effect, there have been over 1,000 orders issued in the state of New York. You can see the difference in order of protection and temporary order of protection there. So most of them are the temporary ones that don't necessarily go into a final or a 1-year order in New York. This use varies significantly by county, by court. One of the areas that I know, there's people on here from Onondaga County or from Oswego, and those are areas in the state that have really championed this law and are raising awareness about it, and therefore I think is one of the reasons why they have increased use in orders. That is compared to a place like in Manhattan, where I've talked to law enforcement who just say, we don't have a use for this tool. We don't have any legal guns here. This is not the tool that we're going to use if we want to seize firearms from someone. And so again, this is not always going to be appropriate, but there are a number of scenarios when someone hasn't necessarily done something that's a crime, and therefore you can't remove their firearms with another method. This is where the ERPO can fit in. So again, Onondaga County Supreme Court has used this about 100 times compared to looking at somewhere like, just picking a random place off of here, Essex County Supreme Court 5 times. So obviously the jurisdictions vary in size, but a large part of why we see an increased uptick in ERPOs in certain counties versus others is the lack of awareness, lack of maybe a champion on the ground who is going to make a point to educate other law enforcement, other advocates, other eligible petitioners about this tool, and therefore it just might not be used as much. One more note on data. Unfortunately, I am a researcher, public health person. I love getting data. I wish that I had access to more detailed information in New York specifically about why this is used and how and when. I just have the raw numbers that you can see up on the screen. It is a mission of mine, and I know Rebecca's, to make it easier to get access to data so we can see more information on these orders, and in addition that we can mitigate any equity considerations if this tool is disproportionately being used against certain communities, specifically Black and Brown communities. We want to make sure that we address that as soon as possible, because again, this is not a tool to incarcerate more people. The purpose of this is a civil temporary order to remove firearms to protect people, not to put them in jail.
So thank you, Lisa. One of the things that I was actually going to point out is that this is a tool that can in fact be used by law enforcement for other law enforcement. There has been an uptick in suicides within the police departments across the state for understandable reasons. And as a result of that, because law enforcement can legally carry guns and legally possess guns, there may be a need, whether they're retired police, off duty or whatnot, for colleagues in the field to be able to do something to prevent access. Same thing with veterans, that there's a high rate of suicide among veterans who also have legal guns in their homes and perhaps are in a position to shouldn't have access to them, at least for a certain period of time in which they're in crisis. Lisa has now put up a screenshot of the website, the court website, that provides for the form that can be utilized. Lisa, I don't know if you have the ability to click on the form to show folks, but it's something that we can share. I see that you just dropped the link.
I dropped it in the chat, yeah.
Click on it. Yes, so if you are someone who falls into a classification of a petitioner, or you are someone who is close to this area and wants to be able to make it easy for someone, bring something to law enforcement or bring something to a household member or a school administrator, you can most easily go to the court's website to fill out a form, an application for an ERPO. You could potentially also get this in paper and hard copy if you just went down to the court. As Lisa pointed out, the New York State Supreme Court in each county is the appropriate court of jurisdiction to file an ERPO. Not everyone knows this, but the Supreme Court in New York State is the lowest court, the lowest civil court, and not the highest. It is very different than the U.S. Supreme Court. So I just wanted to point that out, that this is the court system that handles day-to-day issues like this one. So you will, assuming you're able to go online, you print out this application and you fill it out with all of the information. There it is. that is requested, which will include asking for information about why this is necessary. Has the individual demonstrated that they are in a crisis, that they may be a threat to themselves or others? That could mean suicidal ideation. That could mean a suicide note. That could mean doing something dangerous in their home that may not necessarily be to another individual, but is violent towards inanimate objects or a pet, for example. Has the individual written really threatening things online? Unfortunately, I frequently use the Parkland shooter that committed the mass shooting at Marjorie Stoneman Douglas High School in Florida as an example, because there were so many variables there that had there been an ERPO law in place in Florida at that time, there's no way that this individual would have been able to access guns. And if the parent had guns or access to guns, they would have been required to be locked up. I saw that there was a question that just came in, and I will read them, I promise, before we move on into any more detail. But just getting into the process in a little bit more detail, the first step of this is to get that petition down to the court and filed so that the judge can consider it in an immediate and emergency fashion and determine whether or not a temporary order should be issued. And this temporary order can be issued before a hearing is held, before the individual who may own the gun or have access to the gun has the opportunity to testify, because it is short term. And if the judge determines on the basis of the petition that that individual shouldn't have access to guns, law enforcement can go to that individual's homes, remove the guns, and will be required at that time to give the individual a notice of hearing in which they have 3 to 6 days to come to the court and testify on their behalf or submit additional information opposing the petition. Also at that hearing, the petitioner can bring in additional evidence that there's an issue, and that may be where a mental health provider, for example, can give an affidavit to substantiate the fact that this individual is in crisis. After that hearing is held, it's at that point that the court will determine whether or not the order should be extended. And they may, if they determine that in fact it's not appropriate, then the guns will immediately be returned, or gun will be immediately returned to the owner. And if they do determine that this should be extended, they can extend a final order for up to a year. So it's not indefinite, it is just up to a year. And at that point, at the year point, the petitioner or another petitioner can come back to extend that order. So if there is a need to extend it, that is appropriate. Otherwise, the individual is entitled to come down to the law enforcement office in which the guns are held in custody and turn in their receipt and any other information, and are able to repossess their guns. So again, there's a lot of due process tucked into this. This is really critically important from a constitutional perspective. We're not looking to just grab people's guns and run, as people on the other side of our issue may accuse us. This is a deeply evidence-based inquiry where there are many steps in which a court may decide there's just not enough there to remove the guns from that individual. And, I didn't go into all of the various details of the procedure. I figured a more broad overview would be more interesting, but you should look at this slide in more detail. And if anyone has any questions, I did see that some were dropped into the chat. So let me just take a quick look. Temporarily, what would be the criteria for people to receive their firearm back? If you mean after the temporary removal, I see this question from Dr. April Aycock. Yeah, the criteria would essentially be that they have not, that the petitioner or the petition has not met the burden of proof to show that that individual is dangerous to themselves or others. And it is a fairly high burden. I think it's preponderance of the evidence at the initial stage of temporary order, and then it's an even higher burden to actually issue the final order for more permanent. So if there may be enough there to just remove them for a few days, but after the hearing, perhaps the judge may decide there's just not enough and we need to return the guns. How is this managed if an actual officer who's having a mental health crisis is protected so their job is not affected being that they need their guns to perform their job, but also to not discourage them from getting help and preventing an actual suicide? That's a very good question. And I don't necessarily know the details of how that procedurally would work from an employment perspective with law enforcement. But, you know, I think that it is one of those circumstances in which if that individual really should not have access to guns, whether because they're suicide or they're at risk of hurting someone else for a reason that is not necessarily justified under the law, you know, this is a civil order. It doesn't criminalize the individual. It could be temporary. And it could be a basis to have that person placed on temporary leave. If they can't have access to guns because there's a court order against them, then, and that is the requirement of their job, then, you know, that is a determination that law enforcement would need to make as the employer. You know, I can't speak to law enforcement's policies on this. I mean, perhaps there's someone who is on this call that, you know, could weigh in here, but I do think that there needs to be less stigmatization of mental health crises and suicide threats, you know, within the law enforcement system, and that the more flexible and accommodating law enforcement system can be to placing individuals on leave, paid leave, because they're going through a crisis and they're, you know, facing trauma every single day in the field. I think the more effective we can all be.
And I think just very generally speaking to that last question too is, you know, there's the belief that if people experiencing a suicidal crisis get the help they need when they need it, you know, most people are going to be able to return to their regular functioning, right? It doesn't have to totally define who they are. So obviously recognizing that in professions where firearms are part of the uniform or part of the equipment, you know, that has some added nuances to it. But I think, again, in general, you know, once people get the help they need, that there's an assumption that, you know, people will be able to then carry their firearm again and safely, right? And so that's the expectation we would have of anybody who receives support for thoughts of suicide in the moment. And so I think making that assumption and hoping that that's the same for other professions is part of the equation.
I could speak to that, you know, just to oh, Lisa, I'm sorry.
No, go ahead.
I was just going to point out that, you know, most what the research has shown, and Lisa could speak to this more in depth, is that most individuals who get the mental health care that they need after attempting suicide or indicating that they may be suicidal go on to lead healthy, you know, effective lives. And the problem is that often they don't. And so it's one of the reasons that we advocate for a law like this, because the chances of someone completing a suicide with a firearm are like over 90%. And yet with individuals who potentially attempt with another means, you know, any of the other means that individuals attempt crisis with, the chances of success of completing that suicide are much, much lower. And so we've been able to look at that comparatively and see that those individuals who attempt and do not complete the suicide but go on to get mental health care do not attempt again. And I think that that's a really important point to be made when it comes to individuals who may be in the law enforcement system or in the military that really just need the help and are able to go back in. Lisa, I don't know if you want to speak to this more from a research perspective.
Yeah, those are great points. I want to touch back on the question about a law enforcement officer at risk for suicide or self-harm, because what I've heard from talking to people in various states is that, like Rebecca said, they could be placed on temporary leave. But sometimes, you know, that would mean losing their paycheck, maybe even losing their job permanently if depending on the situation. But another option could be placing them on like a desk job, like keeping their job, but maybe taking them off of, you know, like out of their police cars, taking their weapons away. Obviously, you can't be a law enforcement officer going to serve ERPOs or doing any other function that law enforcement officers do without your weapon, probably. but we don't want to encourage people to lose their jobs because of this. Obviously, that would be a deterrent for seeking help. So there are ways, certainly in New York and other states, that are doing this to have a law enforcement officer keep their job, get the help they need, and emphasizing, of course, this is temporary. This doesn't mean you lose your firearms forever. This doesn't mean you will lose your job forever. And it's also very individualized. The situation is going to vary.
Lisa, I just wanted to answer very quickly two other questions that were in the chat.
Okay.
There's a question about like who litigates this. This is really intended to be utilized by the public. This is not litigation. This is supposed to be user friendly so that, yes, like a law enforcement officer could directly go in and petition for this order, or a district attorney, but it also is an opportunity for someone who is just a family member to be able to go directly in. And it's not an expectation that you're going to lawyer it. The expectation is that you're just telling the story, and that's what the application provides. If that being said, if you are uncomfortable, and I think what we are seeing is that generally a household member, maybe a school administrator, will go to law enforcement or will go to the local DA and have them apply instead. The other question that I saw was the difference between the SAFE Act and ERPO. The New York SAFE Act was a package of laws regulating guns that passed in 2013. And that act, the SAFE Act, includes comprehensive background checks, requiring a background check on every gun sale in New York State. It bans most assault weapons, and also is what actually required the sort of like mental health registry, requiring individuals to be reported to a registry if they are dangerous to themselves or others. This law is a supplement to the SAFE Act, so it's not. It's just an additional law that passed later on, a few years later in 2019.
Right. And I put a link in the chat to a website that my organization, the Educational Fund Stop Gun Violence, runs with the Johns Hopkins School of Public Health. And there is a comparison, a little table in there, 2 pages comparing the ERPO to the SAFE Act. So there's a lot more information in there. The SAFE Act is more focused on a mental illness diagnosis than extremist protection orders are.
Lisa, there's a question about costs, and I don't have handy the exact fee in front of me, but it's less than $10, I think, to file a petition, isn't it? And if it's not, there's also, you can see on the website where the application rests. Mm-hmm. You also can apply for a waiver of the fee. So, the court system does not want financial hardship to in any way get in the way of issuing an order. Mm-hmm. But I can quickly look up what the fee is to make sure that I'm accurate on that, because it's possible that it's a little bit more.
Yeah, that's a great point, because we don't want cost to be a barrier for ever seeking help. And so when we advocate for these laws, we always, suggest that there isn't a cost associated with it, or if there has to be, there's an option to waive that fee. Yes, there's a question about ERPOs at the same time of an order of protection. You definitely can do that. I have heard of folks doing that in Maryland, for example, getting a domestic violence order, which they called a domestic violence protection order, and an ERPO at the same time. What I've heard from law enforcement in Maryland specifically on this is that they go for both, and whichever one comes through sooner or makes it easier to remove the firearm is what they choose. However, I don't think it's recommended to use both of them, but I have seen that be done. And it would be separate courts in New York, someone said. So that's a good point. So now we will talk about how ERPOs fit in with other suicide prevention tools, and get back to Rebecca's point about the means mattering in who lives and who dies based on a suicide attempt. What we know is that most gun deaths are suicides, and most suicides are by firearm, and that's largely due to the fact that they're so lethal. As Rebecca noted, 90% of individuals who attempt suicide with a firearm will die, compared to about 2 to 3% of suicide attempts with other means, such as cutting or hanging. So they are incredibly lethal. What we also know, however, is that if you do survive a suicide attempt, you are not likely to then eventually die by suicide. So putting that critical time and space between someone who might attempt suicide and such a lethal mean of a firearm really decides who will live and who may not live. Access to guns in the home increases the risk of suicide more than threefold. So it's not just having that gun, which is more lethal than other means, but really just the mere presence of a gun in the home increases this risk of suicide. So given the role of firearms in suicide, it is critical to remove firearms from individuals at risk of self-harm. In addition to ERPO, what are some ways of doing this? First, firearms can temporarily and voluntarily be stored with individuals or in some states at gun shops. And Gara and I were talking earlier about gun shop projects or gun maps, gun storage maps, which I will provide another link shortly where you can see which states have those, what some storage options are for getting a firearm out of the home. Firearms can be secured at home using locking devices. This is especially important when we're talking about preventing youth firearm suicide, because these are an age group of people that, under 18 are not legally able to purchase and possess a firearm. But we know that about 80% of youth who die by firearm suicide get their guns in the home. And we know that there are, I think the latest estimates I saw was that there are about 5 million children in the US that are exposed to unsafely stored firearms. So it's just entirely too easy for a child to get a gun in the home because they're not being stored properly. It's also a false assumption that children don't know where the guns are, that they don't know sometimes how to get into the safe, that they don't know how to use a gun. All of those are proven false when we look at the data and how many children access these guns. As young as 2, they can pull the trigger on a gun and inflict serious harm, obviously, or death. So locking devices, storing guns separately from ammunition in the home is very important for everyone, but especially for preventing youth from accessing these guns. And thirdly, on here, we talked about ERPO as another option. And one of the final points on here is a policy called voluntary self-prohibition, or a do not sell list. This is an interesting, a novel policy that only exists in 3 states currently. Virginia just passed this law this year, as did Utah, and Washington State previously had it. I know that there are a number of other states considering voluntary self-prohibition laws this session, including Pennsylvania has already introduced a bill on this. And what this is, some people call this a self-ERPO because it allows individuals who are at risk of suicide to themselves put themselves on a do not sell list or a do not buy list. And what that would mean is that if they did try to go and buy a gun, they would show up on the background check. Obviously, this is all contingent upon a robust background check system and going to get a firearm through a federally licensed firearms dealer. But this individual would be flagged and say, no, you can't buy a gun. You added yourself to this list. And the process for removing varies by state, but usually you can petition to remove yourself from the list. And that takes effect after typically 30 days. So it also acts as a waiting period, which we know is a great suicide prevention tool as well, because sometimes the nature of an individual at risk for firearm suicide can be, I don't like using the word impulsive, but that impulse can change on a day. And so if you put that extra time and inflict a waiting period, it can also save lives. All right, so I mentioned that data in New York is not great. So unfortunately, none of these case studies that I have listed here are from New York. I found most of these through news sources, just Googling ERPO in X state, but there's also been a number of peer-reviewed research studies on ERPO use especially in Washington State, California, and others. So and Connecticut and Indiana, who had kind of the first modern or the first extremist laws, not what we call like a modern extremist protection order. But I just want to go quickly through 4 examples of how ERPOs have been used. This is the case from Washington State. A law enforcement officer that we work with really closely there, named Kim Wyatt, provided me with this in some testimony that she submitted. And this is an example of a girlfriend who filed an extreme risk protection order against her boyfriend because he was attempting suicide and wanted to purchase a firearm to die by suicide. An extreme risk protection order was hearing happened. The couple came in together and they were holding hands. The respondent had, the respondent had no objection to this extreme risk protection order being issued. And he actually ended up being really grateful that someone cared enough about him to make sure that he didn't have access to a firearm. And he wasn't able to purchase a firearm. He survived. And this is one of my favorite examples, just because I think a lot of time people picture this really contentious hearing where someone is really mad and yelling and angry that they don't get to have a gun. And of course that does happen, but there are also situations like this where someone can be really grateful that someone cared enough to intervene. And I've actually seen a number of cases like this. The second is an example from Maryland, another state with an extreme risk protection order, which was issued to prevent a school shooting. There was a Maryland student who posted a Snapchat holding a rifle, threatening a school shooting, saying, haha, I'm gonna shoot up the school, I'm gonna make the news, I'm gonna be famous. Police issued a temporary order, removed firearms in this situation. Similarly, this is a case study from Connecticut where someone was threatening mass violence. He wanted to purchase guns in his state. He wasn't able to. So the police were alerted of this threat by a family member because she said that this family member was going to plan a mass murder. The ERPO was issued, firearms were removed. No harm occurred in this case. And finally, a really interesting way that I'm seeing extreme risk protection orders being used in the last couple of years is to prevent white supremacy and hate crimes. I've seen a lot of cases in California and Washington State, which is where this is from. And this is interesting because I've seen local law enforcement actually working with the FBI to carry out these extreme risk protection orders. There's not a federal ERPO, so it's not like the FBI can go ahead and petition in these cases, but they're working with local law enforcement, identifying people who have threatened white supremacy, threatened hate crimes, threatened something like the insurrection on January 6th, to remove a firearm. And so in this Washington State case, a man posted numerous mass shooting threats on social media, saying that he wanted to kill Jewish people, posting pictures of Nazi artifacts and his gun collection, and an order was granted and 12 firearms were removed from his house. So those are just a couple of examples. I could go on and on. I have hundreds of examples of how ERPOs have been used now, but those are just some that I think are particularly impactful. Rebecca, anything to add there?
No, I was just looking at a question that was in the chat about, who the record keeping and who's notified when ERPO is issued. Mm-hmm. And both when the order is issued and then when it expires, the court system is required to notify and then provide a copy of the order to the New York State Division of Criminal Justice Services, state police, and any other law enforcement agency within that jurisdiction. And then that DCJS actually then reports the expiration to the FBI. So there are a number of different agencies that are notified to ensure that they're like cross-checking what's what, and the court system keeps those records too. It would be advisable for the respondent, the individual who's had the guns removed, to hold on to their receipts, to hold on to any court notices. But ultimately, all of those records are kept within DCJS and the court system as well. I think I saw one other question too. Oh, I was going to out myself. I stand corrected. I grossly understated the fee. It is, I think it's about $200 to file an application. But again, that rarely is actually required, because if you when you file the petition, if this other form, which is right underneath it in terms of the link on the website to waive the fee, that almost in all cases will be waived, particularly if we're talking about a private citizen, an individual in the household or otherwise. So that's just something that I wanted to flag and note for everyone else.
Yeah, and there was another question in the chat about how does an ERPO correlate with the 9.41, 9.45 pickup orders for dangerousness to self or others? And I admit I'm not sure what that is. I don't know, Rebecca, if you know what that is, or if Brian, you can clarify in the chat, and then hopefully we can get an answer. And then there's a question about petitioner not being notified. Sorry, I'm not sure what that is referring to either.
I don't want to speak out of turn, so I will look this up. But if Brian, you want to like elaborate on this in the chat, or even put your mic on and speak to it, you know, we want this to be conversational.
This is Brian. Probably easier for me to speak than to type.
Hi, Brian.
So 941 and 945 are parts of mental hygiene law that allow for either law enforcement and or the Director of Community Services or designee to have someone brought to the closest psychiatric acute hospital for consideration of admission due to dangerousness to self or others. So I was wondering, is there historically been a correlation between this? We haven't seen it locally. I don't know, as any ERPOs that have been done, none of our law enforcement has alerted me to them. So I'm not sure if they're being done in mental health cases in particular or not. And many of the people on this call are some of my colleagues, so I'm sure they're curious about this as well.
That's a really good question. And it was one that came up initially, you know, as a question of whether or not, is this like a duplicative procedure? Is this already covered under the law? And I think one of your colleagues actually responded to this, which is the distinction is one is like an actual mental health hospital intervention where, you know, there's an actual determination that the individual needs to be removed essentially. And an ERPO is really just intended to target the guns. So while, you know, a mental health diagnosis or evidence of a crisis, or the fact that that individual has been hospitalized can work towards supporting a petition for an ERPO, it doesn't necessarily, it's not required and they're not the same thing. I think the other thing that's worth noting is that like an individual does not have to reach the point of needing to be hospitalized for there to be an ERPO issued. It may be someone who has demonstrated some, you know, some suicidal ideation or some dangerous behavior, and the family member just wants to prevent them from buying a gun in the first place. And that's an ERPO is not only for the purpose of removing, but it also can be filed and prevent an individual from buying a gun in the first place, which is important because to be prohibited under the SAFE Act and through a background check from buying a gun, the standard is much higher. But if an ERPO is issued, at least temporarily, that individual, whether they could pass a background check or not, would not be able to purchase or possess a gun. I hope that answers your question.
Yeah,
As one of my colleagues clarified, the 941 and 945 does not admit the person to the hospital. It's a pickup order authority only to take them to a hospital for possible admission. And
Okay.
so often, many of those people also have guns and may have been making threats with guns. So thus, you know, it's really, from our perspective, important that if there is an expectation of correlation, it's not occurring, I guess would be my take on it.
Yeah, I think that these should go hand in hand because as you just pointed out, if the individual is taken to the hospital but not admitted, and then they can just, or they are admitted, but they're released a few days later and they're just going back to their firearms, then we're back to square one again. So I think it could be very effective to issue an ERPO at the same time so that if that individual is released quickly or just goes home, that at least their firearms are removed from their home. And you know, again, like every court assessment is different, but the mere fact that they were brought in and, you know, a law enforcement officer kind of detailing this in an affidavit may not be enough to hospitalize the individual without their consent, but it would be enough potentially to at least remove the guns for a temporary period of time.
Can I ask a question? It's kind of long, so I didn't want to put it in the chat. So my question is related to the gun. So say someone does have a gun in their home and it's removed, where are the guns housed and are they being looked at? So for example, is it going to be any kind of lab that's going to be looking at the guns to see if it was related to any, homicides that has occurred in the community. So just curious about that.
Yeah, that's a great question. And I saw your other question about how to waive a fee. And so I've put in a link in the chat to how, the form to fill out to waive a fee. To answer your question, the firearms are stored usually with law enforcement. And I've never heard of them being looked at in association with a crime. Obviously, there's a lot of concerns there if law enforcement were using this as a way to kind of retrieve a gun from another, from a crime, and then would be using this civil order to then put someone in jail. That is very problematic. And so I have never heard of that happening. I don't know, Rebecca, if you have any more insight on maybe New York specifically where the guns are taken or if they're inspected at all. Oh, you're muted.
Sorry about that. That was an accident. They're generally taken to the law enforcement office of wherever the individual, like whoever had initial custody to come in and take the guns in the first place, and they're just stored there. I don't think that they're examined. I think there would have to be a completely separate process and warrant in order to actually examine the use of those guns in a crime. And this has been, this is an issue that Lisa flagged in the beginning and is worth pointing out, which is that we understand that this is just one tool that will reduce gun violence in certain circumstances, but it has been asked, in the context of illegal guns and individuals who are disproportionately impacted, in our Black and brown communities in our cities, is this something that's going to be helpful? And the reality is that understandably, a lot of individuals who are impacted by gun violence don't trust law enforcement. They don't want to contact law enforcement. And whether or not, the intended use of the gun was for a crime or for protection, but it was purchased illegally or not, obviously by contacting law enforcement in the course of reporting this for a civil order, it could compromise them. So we understand that it may not be appropriate in all circumstances and may not be the recommended choice, for example, by community violence intervention workers to individuals who may be in like a domestic violence situation where there's an illegal gun in the home. That being said, it is worth noting that these guns should not necessarily be taken aside by law enforcement and examined or investigated for a purpose that's outside the scope of what the petition was ordered for. And I don't know if any law enforcement on the call can speak to this, in which maybe there was some like crossover.
There was also a question in the chat about, do the petitions receive immediate court access the day they are filed? So if a temporary order is issued, it's in effect until a final ERPO hearing, but no less than 3 and no more than 6 business days after the service of the temporary order. Obviously, there's due process concerns if a temporary order is allowed to be in effect for, what we say more than 14 days, because we want to make sure that the respondent has a chance to, state their case before a court. There are some states that actually allow 24-hour access to ERPO petitions. I don't believe that New York is one of those states. You can't file one of these 24 hours a day, 7 days a week. But for the temporary order, there's not an unlimited amount of time that they're allowed to stay in effect. And the burden of proof is higher for the final order.
And I don't know if this is a separate question, Lisa, but it also begs the question of like, how quickly will the court consider it? And it really is intended to be like, an immediate way of protecting the individual. So the court, as soon as they receive it, really should immediately review the petition and issue an order if they think that there's enough proof there.
Right. It's in the title, like extreme risk. This is an extreme risk and immediate threat of harm. And so that is the hope that these get addressed quickly. So, okay, it's already 1 o'clock. I'm gonna go through the remainder of our slides, and then hopefully we can do more time at the end for some Q&A. I just want to turn now to suicide and intimate partner violence quickly, because I think this is an important way to kind of wrap up our discussion before Rebecca gets into what you all can do and some next steps here. What we know, I've reiterated this a number of times, means matter. Most suicides are by firearm. Most intimate partner homicides are by firearm. If you use a gun, there's less of a chance that someone will survive if, the intent is to die or to kill someone. Access to firearms increases the risk of suicide, as I mentioned, but also the risk of intimate partner violence homicide. When a woman, it's usually a woman, is living with an abusive partner who has access to a gun, the risk that she will die increases fivefold, or 400%. More than 1 in 4 homicides in the US are related to domestic violence, and the use of a firearm in these situations increases the risk that there will also be additional fatalities or multiple fatalities. It's not uncommon for those additional fatalities to be a perpetrator of an intimate partner homicide who then dies by suicide. So research shows that, well, my research actually shows that many domestic violence mass shooting offenders die by suicide. And so I wanted to briefly touch on some research that I conducted with faculty at Johns Hopkins. This came out earlier this year. And what we looked at was the role of domestic violence in mass shootings. And we found that the majority of mass shootings in the United States are related to domestic violence. But because this is a suicide prevention audience, I want to highlight the findings related to suicide. And what we found was that between 2014 and 2019, 55 perpetrators of mass shootings, of which there were about 100, died during the incident, and the vast majority of them died by firearm suicide, followed by incidents where they were killed by police. And sometimes that's called suicide by cop. But really, the suicide firearm suicide is the most common way that a perpetrator would die after a mass shooting incident. We saw that 36 of the 39 mass shooting perpetrators who died by firearm suicide were DV-related mass shooting perpetrators. So these are perpetrators who are killing their family or intimate partners or children. They are the ones that are more likely to take their own life after this mass shooting incident. And we saw that 65% of DV perpetrators died during the shooting. And of those that did die, almost all of them died by firearm suicide. So there really is this connection between domestic violence and mass shootings, but also domestic violence perpetrators and dying by suicide after this event. So we can look at mass shooting prevention also as firearm suicide prevention if we're addressing these individuals at risk of harm. They're not only threatening harm towards others, but oftentimes threatening self-harm. And so we can prevent a lot of these situations with a tool like an extremist protection order, where we can remove a firearm before this happens. So I will turn it over to Rebecca now for kind of what you all can do. And then I want to show a few resources at the end.
Thanks, Lisa. So it is always difficult to know what we can do, although I think in this group, participants in this program actually have immediate access to being able to provide input and also be potential petitioners, whether you work in law enforcement or someone who is potentially at threat of injuring themselves or hurting themselves. But if you're not, you should consider getting more involved in helping educate your family and friends, your professional colleagues, and also your community. And one of the things that Lisa and I have been very focused on as she has done this research and attempted to collect more data is that although we passed the law in 2019, there's just definitely a lack of information out there, a lack of training, and therefore a lack of implementation. And I'm not just talking about within the general public, I'm talking about within like law enforcement departments and district attorneys' offices. So if you have access to the ability to provide those kinds of trainings, and you can either bring us in or we can provide materials to you or we can help set it up. But I strongly believe that the next step of this is educating those individuals who are closest to the problem to be able to access this tool. And certainly if you're joining this as, a resident of New York and a member of the community and looking to more widely spread public awareness. New Yorkers Against Gun Violence, in conjunction with CSGV, has just launched something called Connecting Communities, which is going to be a statewide series of education forums. And we're looking for local voices and local organizers to help us coordinate those forums. For the past year, we've been doing them virtually, which I think has in a lot of ways been very effective, because just like right now, we can, immediately during lunchtime reach 80 people from all over the state. But we also know that people are looking to have more intimate or in-person conversations as well. And so, I will be traveling also with my team more frequently to give these talks and to help amplify the local work that's being done on the ground. The idea behind Connecting Communities is to really bring in different communities within the same regions that may be dealing with gun violence in different ways, or who have misperceptions or misconceptions about what the best solutions are to reducing gun violence, and to allow those, again, who are closest to the problem to use their voices and their expertise to educate the broader public. So please be in touch if that's something that interests you. I'm definitely looking for more volunteers. I always need them. And like I said, the best advocates are the ones that really are closest to the issue. So please reach out. I think my contact information is in the slideshow, and we can also drop it into the chat.
Yes, so we will display it at the end and drop it in the chat. Before we open again for some final questions or comments, I want to share a few resources from my organization or partner organizations that we work with. And the first is called preventfirearmsuicide.com. This is what we think is a great resource for all things related to firearm suicide prevention, addressing this issue from the individual level, the relationship level, the community level, and the society level. So a lot of the interventions that we talked about today, from extreme risk protection orders all the way down to lethal means safety counseling, having a healthcare provider, a clinician talk to their patients, talk to them about firearms, the risks that they pose in the home, the need to remove them during periods of increased risk. And so I really encourage you to check out this website for interventions, policies, the latest research on firearm suicide prevention, the latest data nationally and in all 50 states on firearm suicide, both the number of deaths, the rates of suicide death, demographic information, race, ethnicity, age, everything you would need to know really in your work or to be an advocate for suicide prevention. So that's the first resource. The second, I already dropped a few of these links into the chat, but this is our partnership website with Hopkins. That is all things related to extreme risk protection orders. We have detailed process information for getting an extreme risk protection order. We outline information that differentiates it from the SAFE Act or from other acts in New York State. You can see which other states have extreme risk protection orders, how their names vary, how their processes vary, etc. So please check this out. I can see my screenshot's a little outdated because I wrote 17 states in DC. It's actually 19 because two new states this year, so or last year. So those are the two resources I wanted to cover. There are a few more here. The first is a comprehensive document of all of the data behind extreme risk protection orders. So I've read all the studies on them. I have summarized them. We have recommendations for extreme risk protection order policy and implementation, and a number of other resources. So I will put our contact information at the up on the screen now. And yes, you will receive a copy of these slides. Gara has them in PDF and PowerPoint, so happy to share both versions. And I will drop my email as well.
Yeah, so for everyone who registered for today, we have your email as part of that registration process. So we will make sure that you get a PDF in the recording, and then we'll also be sharing this in other avenues as well. So first, Lisa and Rebecca, thank you so much for covering so much territory in such a short period of time. And I've got to say, this has been one of the most interactive conversations we've had. And we have a lot of great presenters and a lot of great topics. But I think that, you know, this was fairly new in terms of information. And so I think we started a good conversation. For folks who are on the call prior to opening the waiting room to everyone Lisa and Rebecca and I were talking about, that we really don't want this to be one and done. And as Rebecca noted, right, we want to figure out what's the best way, the most efficient way, the most effective way to continue this conversation, to get folks involved who want to be. So whatever that looks like, it certainly sounds like, Rebecca and Lisa would both be open to being contacted about where to go from here. And, I don't know if there's value in, we're budgeted for 90 minutes. We certainly don't need to stay the entire time, but if there's any value in talking about your experiences, what does this look like in other states? Like, what's the progression been from, we just got the law on the books to, what are other states doing? And are there any lessons learned, so to speak, that New York can take away from that?
Definitely. I think that what we've seen is that we've tried to pass these laws in as many states as we can. And, we've made tremendous progress since really 2014, when the first modern extremist law was passed in California called a gun violence restraining order. Since then, a lot of my work has been updating the laws with new recommendations that we have, including, how long should a temporary order be in effect? Should these orders be applicable to minors who might not actually be able to legally purchase firearms? And all of those recommendations are in the resources that you'll see in these slides when they get sent around. We've also tried to make access to data easier. We want to make sure, again, like Rebecca and I have said a number of times, that we can see how this is being used. We can mitigate, disparate impacts on certain groups as quickly as possible, and not just kind of let this run its course and never check back and evaluate how it's going or what can be improved. We really see this extremist protection order as a tool that has to evolve as we learn more about how it's being used. And thus far, we just don't have a ton of data. We know that it's effective in preventing suicide. There's a study that Jeff Swanson did out of Connecticut that showed for every 10 to 20 orders issued, 1 life was saved. So if we're talking about 10,000 orders across the country, or 5,000, again, I don't have the total number, but it's over 5,000 across the country. That's a lot of lives, and even 1 life saved, we believe, is worthwhile. So we need to learn more about how it's being used. We need to evaluate it in how it's preventing mass shootings or domestic violence. And we want to make sure that in the advocacy stage that more groups are brought to the table, because what we have heard is that some states that have passed this law and been implementing it really didn't get community buy-in. And so there are a lot of people that may be skeptical of this tool. I talk to people in suicide prevention who say, this is just not the tool that I'm going to use to prevent suicides in my state. I talked to a clinician about this, and she thinks it could be okay, but she's not really warming up to it. And so we want to get all those stakeholders bought in really as early as possible and hear their concerns, so that the laws can reflect what the community wants and what the community needs.
Thank you. There was a question regarding New York State DCJS. Do they have a search option to check for individuals who have active ERPO orders?
That is a good question, and I don't know the answer to it, but I should know, and it's something that will likely come up again. So I will find out, and perhaps we can have a response to that question in the distribution of the materials.
Yeah, thank you.
I do know I don't know if this question was addressing privacy concerns, but I know that one of the biggest barriers that we've had to getting data is that people, are worried that it's going to become public that they were responded to an ERPO, and rightfully so. And so I want to clarify that when I say I want access to data, I don't need someone's name, I don't need their address, don't need their date of birth. I just kind of want to know why the order was issued. Was it for suicide? Was it for domestic violence, mass shootings? And what happened? Was it rejected? Was it not rejected? How many guns were removed? Those kinds of things. I don't need to know people's personal information. And Gara, I don't know if you're able to send me or save the chat, but I would love to get back to some people who've put their contact information in here.
Yeah, my understanding is, which is, somewhat limited, but with Zoom, that with a recording, that the chat box is automatically archived along with this. So fingers crossed that I know.
If not, please email us with your question.
Great.
There's a question about New York gun shops, whether they need to search a separate database to check for ERPOs. Great question.
No, so, New York doesn't have a separate, is not a point of contact state. And so the DCJS is required to notify the FBI so that when a NICS check is run in a gun dealer shop or at a gun show, that this would show up. And does beg the question in terms of like bureaucratic process, like how long does it actually take to get that information into NICS, which is a problem, but that theoretically is what's supposed to happen.
There was a question from a little bit earlier on, and this may have been answered, but is there, once the order is removed, is there a record anywhere, and who has or can access the record if one exists?
Well, I think we actually built into the law that passed that the record is cleaned. It's cleared after the ERPO is lifted. So if it's not intended to be permanent, it's not on your permanent record. It's not like that. It's really just a civil order.
I will say in some states I have seen individuals that are respondents to more than one extreme risk protection order. So there may be some states that do keep some records. Someone maybe has an order expire after a year, and then a year later there's another extreme risk protection order issued. So I guess that could theoretically happen, and that means that there may have been some record, but again, like Rebecca said, it's not like a permanent record that is going to show up when you try to buy a firearm if you're not prohibited.
I mean, I think because it's sealed, essentially, if you were to later be convicted of a crime, I don't know that that could be utilized in any way historically as data, especially if it has absolutely nothing to do with, the crime that has been committed.
Mm-hmm.
Another question in the chat, does the ERPO have to be served to the individual to be, quote, in effect?
Yes. So once the petition is filed and issued, then it is incumbent upon the court to ensure that law enforcement delivers that ERPO order directly to the individual, and that those guns are removed with the exchange of paperwork and a receipt that will actually detail the make and model of the gun, where they were stored, very explicitly in that. So yes, notice is required. You can't have an ERPO issued against you without there at least being a delivery of that order to the residence in which you live and where those guns are stored.
And once the order is issued, the respondent has to immediately surrender all of the firearms in their possession. Some states give like a little bit more time, but I think it's just says immediately in New York's law. Yes, to answer your question, if an individual is resistant to an ERPO, would law enforcement be able to do more to protect in this situation? There are situations where a search warrant is issued to seize firearms, but the goal, is that this is peaceful and not like law enforcement breaking into your house and taking whatever they find. Or, there's obviously issues with a search warrant. If law enforcement goes in and finds something else illegal in your home, they're not allowed to act on that. That wasn't the purpose of why they were going in to search your home. They were trying to remove the firearms that they know were there. So yes, there are options if someone's resistant to an ERPO to ensure that the firearms are removed.
Right, because once you're resisting a court order, then it becomes a certain level of criminal activity. So, it's not intended to, it's a civil order, and that's what it's intended to be, and not in any way criminalized. But if you're opposing that and not complying with the order, then, that may present a problem.
Mm-hmm.
Not seeing any other questions in the chat, so we'll give it just, I guess, one or two more minutes to see if there's any final questions or thoughts or observations. I'm curious, maybe just in the terms of the chat function for folks who are on the call, if anybody has experiences having used ERPOs, just to either thumbs up or, just to maybe talk about that.
Just put our emails back in case you want to
Thanks.
contact us.
I have to say, I'm so impressed with the number of people that participated in this and also that stayed the whole time. That's great from our perspective, and we just really appreciate like the interest and commitment to the issue.
It's like Brianna gave a thumbs up utilization. So I don't want to, prolong things. If there's nothing else, again, my sincerest thanks to Rebecca and Lisa for, sharing their expertise and their passion around this topic. And again, absolutely want to encourage folks to, if this has sparked an interest or furthers an interest in this topic, whether you're looking at it through the lens of gun violence in general, suicide prevention, domestic violence, and you live, eat, work, and play in New York State, to reach out, right? How can we support your interest and your efforts in this? So you've got the emails for Lisa and Rebecca, and certainly if there's interest specific to suicide prevention, I'm happy to try to help further the conversation in a meaningful way. And if there's nothing else, I'm going to stop the recording.